Bringing you to an update on the Oxford High School shooting. An attorney representing some of the families updating the lawsuit after viewing surveillance video. Let's listen right here on Live Now from Fox.
Had any month that ends in day ends in 30, of course, is another month that these folks have to think back on what happened 8 months ago now. And I was given the opportunity, and I think, again, publicly, Prosecutor McDonald and her staff, but especially Mark Keese, who was in the room with me, to show me the video that we still haven't gotten. And we're working on what's called a protective order. And I want you all to know, because you all, we've talked about exchanging information. Anything that's not protected, I will always share with the press. It is important that you folks know the truth, and just as much as my clients know the truth. But it's been difficult for a lot of reasons that I won't bore you with today that you already know. But I went and saw the video with the assistance of the prosecutor. Now, mind you, I've had 15 minutes with it. Not that they were timing me, but that's how much I took. And there were screens with like 30 different, views, if you will, in the school. So I scribbled down as much as I could. But one of the things that I found out that I can tell you I didn't know about, and more importantly, our clients didn't know about, was the involvement of Kimberly Potts, P-O-T-T-S, who was an Oxford Community School security guard. Let me repeat, security guard. Now, she was employed there. She was armed. She had a gun. She had a body camera. Just what you'd expect from a security person. And I know that none of you have heard anything about her, because what you're going to hear today is why she's being, we are seeking her addition to our lawsuit. Ms. Potts, as I told you, was a security guard who was on duty and had her standard weapons and instruments that I just told you about. And what she ultimately did was, when the shots rang out at 12:51, she apparently, according to what she has told the investigators, she was confused because she heard on the radio that there was Alice drill. And if you want to know what an Alice drill is, even though I think most of us know, you could do what I did last night and speak to my 12-year-old, because that's what they have now. Alice drills to prepare for a school shooting. So for whatever reason, and we all know that if she's a security guard, she would be told in advance that there's an Alice drill coming up, just like the students are told this is a drill, so they don't freak out and think it's the real thing. But they tell them we're supposed to act like it's the real thing, so we practice, okay? Well, apparently Ms. Potts was confused that day and thought it was a drill. What I don't know, and what we need to find out, is exactly what she did for the next 4 minutes. Because the one thing that we can certainly all agree on is she did not run and find Ethan Crumbley in the hallway. And we know that Ethan, when Crumbley came out of bathroom 1, I'll call it, he shot a number of people. And I won't comment any more on that. And then he walked through the hallways and inflicted more harm, ultimately on a teacher in a classroom that he shot through the door, ultimately on Tate Mere, and then ultimately in what I'll call bathroom 2, where he shot and killed Justin Schilling. And Keegan Gregory was in there as well, and luckily Keegan ran out just before or after Justin was shot, and thank God was not shot, but obviously was scared, as anybody would understand. Technically speaking, what we've done is we filed a motion to amend our lawsuit. We call them a complaint. This is the fourth amended complaint. And I tell you that because I keep telling you folks, after 36 years of practice, this case has new things. I don't think I've ever had to change my complaint 4 times ever in a lawsuit. I don't think. It is highly unusual. And the reason why is because we keep finding out new things like every day. because of the lack of transparency, in particular of Oxford Community Schools. They should have told these folks and their constituents what happened, so they knew what happened, but they didn't. They've said nothing, and they continue to say nothing. They still have done no investigation, and they're not going to, and when they do, you watch, they're going to try to keep it from the public and try to hide it from us. What we now know is this: when the shots rang out at 12:51, ultimately we know that Ms. Potts walked down the hallway where ultimately she found Tate Meir. Obviously on the end I have Trent Meir, Tate's brother, older brother, and Buck Meir, Tate's dad. And I'm sorry to have to talk about this in front of you. Tate had already been shot. He was on the ground. Ms. Potts told the investigators that when she looked at Tate, she thought, boy, this Alice drill, they're really using good makeup. Good makeup. So she walked past Buck Meir, Tate Meir, and walked down toward the bathroom. In the bathroom, with 100% certainty, bathroom 2 was Justin Schilling, was Keegan Gregory, two-stall bathroom. They were both hiding behind the door, and then in came Crumley. Moments later, we on the video can see Potts, after she left Tate, for some reason she told investigators, it now dawned on me, even though she said she thought it was good makeup, it dawned on her that this must be real, even though what the evidence is going to prove that she should have known and did know was real the whole time. She walked down the hallway and directly went to bathroom 2. Why? We don't know that yet, but my belief, the evidence will be that she was told that that's where Crumley was. She went to the bathroom door. She pulled the door open, and then all you see is her shutting the door and then walking down the hallway. She had her gun in her hand, so she knew. She told investigators that she didn't even look in the bathroom, didn't even know why she was opening the door really, and didn't hear anything. And what we're going to prove in this case, folks, when we go in and take photos of the bathroom to prove that which should be obvious to all of us, anybody would have seen 3 young men in that bathroom, because Justin Schilling was still alive and there had been no shot in that bathroom yet. When she shut the door, you can tell by the video that there must have been a shot. I couldn't hear it. There's no sound on these. But ultimately, we see Keegan running out, and we see folks going to the bathroom. They clearly heard the shot. And that's when Crumley came out. Crumley had his COVID mask on his face. He put his handgun on top of a garbage can, got on his knees, and raised his hands. Ultimately, 2 sheriff deputies came and ultimately arrested him, got him down, and handcuffed him right then and there. So what we believe we've asked Judge Chabot in our pleadings that we filed today, please let us amend, change, add information to our lawsuit yet again so that we can add Ms. Potts as a party defendant, is what we call it. So she is now a member of the Oxford folks that include the teachers, EJAC, Fine, and Hopkins, who we all know had interaction on that Monday the 29th and Tuesday the 30th. And now she is yet another Oxford community person. So Oxford Community Schools, you will recall, is already a party to our litigation. We talked about that last week. This is one of the first cases in probably 3 decades where a judge has allowed us to sue them when they are absolutely blanketly immunized. They are barred from being sued. And Judge Chabot granted our motion knowing full well that we are taking governmental immunity head on in this case because it's wrong and it's unfair and it makes people that work for our government have rights and privileges far above the rest of us, that no one's above the law. And So we've already sued them, and we've had allegations of them being responsible for all those other folks, but now for Potts as well. What should Potts have done? Well, folks, she was a 20-some year Oakland County Sheriff deputy. The second that she heard shots, the second that she was told that there's a shooter, we all know, sadly, through Uvalde, Texas, what the protocol is now. And that is, you draw your weapon and you go. You go to the shooter to try to confront them to end the shooting one way or another. And it shouldn't have taken 4 minutes for her to find him in this school. The shot's only coming from one place. Number two, when she got, and if we believe, and the evidence will show, that had she done that right away and done her job appropriately, then there would have, after those initial shots, there would have been no more. Please recall that Crumley voluntarily surrendered to police without a shot, put his gun down when he saw the police coming at him with a gun, and we're going to prove other things in this case, like that he was never going to confront police, and we'll talk more about that later. Number two, had Potts done her job and gone in the bathroom, it's called clearing the room. Something, sadly, that we all have seen in movies and television now probably every day. Clearing means a security officer or a police officer literally goes in and looks through everything to try to make sure there's no one in there that's trying to hide or prevent them from detecting them. Had she done that, clearly there would have been Crumley with his gun. So we believe that had she done her job, there would have been at least the death of Justin prevented for sure, and Keegan from having to see what he saw in that room. So the steps are as follows. Now that we have filed this motion, Ken Cara and Jeff Stewart of our office, we've noticed the motion for as soon as possible. We're hoping that gets before Judge Chabot next Wednesday. There is a possibility it gets pushed over to the following Wednesday. We will certainly keep you advised of that. This is not a very contentious situation. The other side will not agree to it, but this is something that judges typically grant because it's still early in the case, and Judge Chabot understands that we're not given access to everything yet, so this is unfortunately one of the byproducts of that. So it is our high expectation that she will grant this motion and allow us to therefore serve Ms. Potts and Oakland Community Schools as part of our case. So really that's what we wanted to share today. I've asked our clients, who you all probably know by now. I told you about Trenton Buck, of course, Mr. Stewart to my right, Ken Carr, our attorneys, and Ms. Gregory Megan on behalf of Keegan, and of course Craig Schillen on behalf of his son Justin. We're not going to do prepared statements for them. They are here to answer your questions. I did want to give a shout out to Jill Suave, that is Justin's mom, who, I'm going to read this to you. I wouldn't normally, but I want you to know her thoughts today. Morning, Ven, I won't be able to attend today. It's just too traumatizing. Can you say something like this on my behalf? So yes, Jill, I am. Although there is nothing more important to me than seeking justice for Justin, these latest developments are extremely difficult to process and heartbreakingly unbearable to accept. The only comfort we have is knowing that finally, after 8 agonizing months, the truth is coming to light. I'm very grateful to the entire Venn Johnson Law Firm team for their dedication to ensure that it does.